People of the State of Michigan versus Robert Austin. These are files 1923116, 2023453, and 2123627. Mr. Austin was here earlier in the week to enter a plea, and he indicated in the middle of that hearing that he had some questions that he needed clarified, and so we adjourned in order for Ms. Yancey to talk to him. Ms. Yancey has talked to him, and now Mr. Austin is satisfied that he understands exactly what's going on and is prepared to enter his pleas. And so, is that right, Mr. Austin? We talked, and you've had all your questions answered. Is that right?
Yes, Your Honor.
Okay. So if you could raise your right hand, do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
So, Mr. Gabriel, if it's the same offer as on Monday, is it?
It is, Your Honor.
All right. So, Mr. Austin, the offer in 1923116 is that they would dismiss the charges of criminal sexual conduct in the 3rd degree and the 4th degree for a plea to the amended information, adding a count of accosting for immoral purposes a child, and that is a felony punishable by up to 4 years and or a fine of up to $4,000, and is also subject to the Sex Offender Registration Act. Also, DNA will be collected at the time, if not done already. And in file 2023453, you would plead to the amended information count of assault with intent to commit sexual penetration, a felony punishable by up to 10 years, along with mandatory AIDS, STD testing, and DNA was to have been taken at the time of arrest. The other count would be dismissed. In file 2123627, a file containing a count of breaking and entering a building with the intent to commit larceny would be dismissed. In addition, the prosecutor would indicate that they would recommend a local jail cap and agree to remain silent as to any other terms of sentencing. Now, Mr. Gabriel, is that correct still?
Yeah, it is correct, Your Honor.
Ms. Yancey, is that your understanding?
It is, Your Honor.
And Mr. Austin, is that your understanding?
Yes, sir.
Okay. All right, so Mr. Austin, in file 1923116, the amended information count 3, accosting a child for immoral purposes, a felony punishable by up to 4 years in the Department of Corrections, subject to the Sex Offender Registration Act, and or a fine of up to $4,000. To that charge, how do you plead?
I don't know. I'm guilty, I guess.
Well, no, it's not I guess. It's I'm guilty or not guilty, but you can't say I guess. So, you know, for me to accept a guilty plea from you, it has to be done knowingly, understandingly, and intelligently, and voluntarily. So do you understand that? So how do you plead to that charge?
Guilty.
Okay. Has anyone promised anything other than what we've talked about in court today?
Not that I'm aware of.
Okay. Has anyone threatened you?
No.
Are you doing this of your own free will?
No.
No, you're not doing it of your own free will? Somebody's making you do this?
Oh, no, sir.
So you are doing it of your own free will?
Yeah, sir.
You could choose not to do this and go to trial. You understand that?
Yeah.
Okay, but you want to take the advantage of this plea offer is what I understand. Is that correct?
Yeah.
Okay. And Ms. Yancey, he's previously been subjected to a forensic exam. Is that correct?
He didn't do a forensic exam, Your Honor, but he did do an exam by Dr. Talbot.
Okay, and he was found, well, I mean, I have a report here from October 29th, 2019 for competency that was entered in district court from the State Forensic Center, Center for Forensic Psychiatry, where they found that he was competent to proceed.
Oh, I apologize, Your Honor. I had the second file open. I apologize. Yes.
Okay.
There was that.
So the finding there was overall, Mr. Austin, though intellectually disabled and immature, is accurately aware of his legal situation, reasonably concerned, and can discuss his defense in an informed and reasonable manner. It's the opinion of the examiner that he understands the nature and object of the proceedings against him and is capable of assisting rationally in the preparation of his defense, and therefore is competent to proceed. Is that correct?
That's correct, Your Honor.
All right. All right. So, Mr. Austin, I want to go through these rights. Now, I know Ms. Yancey sent you these in writing, but I'm just going to read them to you and make sure you understand that you're giving up these rights by pleading, okay? So you understand that if you plead guilty, you're not going to have a trial of any kind.
Yes, sir.
And you also understand that by not going to trial, you're giving up the right you would have had at trial, which is to be tried by a jury, to be presumed innocent, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question the witnesses that appear against you, to have the court order witnesses you have for the defense to appear at trial, to remain silent during the trial and to not have that silence used against you, or to testify at trial if you want to testify. You understand you're giving up all those rights?
Yes, sir.
And if your plea is accepted, you may be giving up the right to appeal certain issues that would otherwise be appealable if you were convicted at trial. Further, any appeal for your conviction and sentence pursuant to the plea would be by application for leave and not by right. You understand that?
Yes, sir.
Okay. So here it alleges that you, on or about June 26, 2019, while in the city of Three Rivers, the county of St. Joseph, did accost, entice, or solicit a child less than 16 years of age with the intent to induce or force that child to commit an immoral act, to submit to an act of sexual intercourse, or an act of gross indecency, or other act of depravity or delinquency, or did encourage the child to engage in these acts. So it's alleged that back in June of 2019, you were in the city of Three Rivers. Is that correct?
Yes, sir.
And did you ask a girl under the age of 16 to have sexual intercourse with you?
Yes, sir.
And at that time, you were 18?
Yes, sir.
Okay. And you knew that, well, and as a point of fact, that she was under the age of 16. Is that correct?
Yes, sir.
Counsel satisfied that a factual basis has been established by the defendant's statement of facts in that file?
Yes, Your Honor.
Yes, Your Honor.
All right, then. In file 2023453, here you're charged with assault with intent to commit sexual penetration, a felony punishable by up to 10 years, mandatory AIDS STD testing, DNA to have been taken upon arrest, also subject to the Sex Offender Registration Act. How do you plead to that charge?
Guilty.
Now, has anyone promised you anything else in this case to get you to plead?
No, sir.
Anybody threaten you?
No, sir.
You do this of your own free will.
Yes, sir.
And again, you understand you're giving up all the trial rights that we just previously discussed as in the other case. You're giving up all those rights.
Yes, sir.
Here it's alleged that sometime between May 1st of 2020 and June 15th of 2020, you did assault another person, in this case, a girl under the age of 16 with the intent to commit criminal sexual conduct involving penetration. So did you engage in sexual conduct involving penetration with a girl under the age of 16 while in the city of Three Rivers in May or June of 2020?
Yes, sir.
Are counsel satisfied that a factual basis has been established by the defendant's statement of facts?
I am, Your Honor.
Yes, Your Honor.
And are either counsel aware of any other promises, threats, or inducements?
I am not, Your Honor.
None, Your Honor.
Has the court complied with the court rule?
Yes.
I believe so, Your Honor, but just because so much happened, did you ask him about the probation? I think you did, but are you on?
Yeah, are you on probation or parole, Mr. Austin?
No, sir.
You have, Your Honor. Sorry, there was a lot happening. I couldn't
Oh,
remember.
you're right, I missed that. Okay, so I find the pleas made are knowing, understanding, voluntary, there's a factual basis. Therefore, I accept the pleas. We'll set these for sentencing on July 2nd. Now, in all of these cases, Mr. Austin, where it alleges a victim under the age of, or a minor involved in a sexual assault, the mandatory by state law, the bond be canceled. So bond's canceled, and we'll see you back here for sentencing on July 2nd. I've signed the order for the DNA sample to have been taken. Now, that should have already been done, but if it isn't, they'll do that now. And then the deputy's going to give you that packet that you need to fill out so they can do your pre-sentence report. And we'll see you back here for sentencing in July. And it's also my understanding that these cases will run concurrent with each other. And so that should be made part of the record too. All right, with that, that concludes the cases. Mr. Knopfsinger's case will be dismissed and the other two cases will proceed. And thank you very much.
Thank you, Your Honor.
Oh, wait, before we go off the record.
I just did, hold on.
Okay, we're back on the record. We intentionally did not use any identifiers for the victims, but it's extremely important that the record reflect that Ms. Yancey, you reviewed the police reports with Mr. Austin, and you have no doubt that the victims in this cases were under the age of 16.
That's correct.
All right, so with that having been done,